That's what I wanted to have you on. We're going to talk about Rahimi. United States v. Rahimi is the case that the Supreme Court has taken up. This is a case that involves not a great guy. I think that's one of the consensus views. I've talked to a lot of experts about this. We've got more reporting on it over at the Reload if people want to read from some of the other experts out there who I've reached out to for this. We'll probably have some more on in the future too. It's going to be several months before this case gets litigated further, but he's not a good guy. That's established. He's accused of violence against his child's mother is why the restraining order was issued against him. And then he's accused of a number of other crimes that aren't related to this case, but sort of establish what kind of person he is, multiple shootings, drug dealing, so on and so forth. But his case is specifically about whether or not somebody who is subject to a domestic violence restraining order can be barred from owning guns under the Second Amendment, right? Is that the basic question as you see it?
Yeah, I think at the end of the day, what the Fifth Circuit Court of Appeals down there in Louisiana, Texas said, that federal statute, and it's going to be very important this is a federal statute, we'll talk about why in a few minutes, but 18 U.S.C. 922G is a provision of the federal code that explains those people that are what are known as prohibited people. And there's a list of them. There's about 9 or 10 different categories. The number one category that, Stephen, we always talk about is the felon in possession. That is someone that has been convicted of a felony as defined by the statute, which is uniquely defined and broadly so, whether or not they have a firearm. If you are convicted of a felony and subsequently have a firearm, you are committing a federal crime, even if the underlying felony is, let's say, a state crime. Now, what's interesting about the Rahimi case is that contrary to what you would think the United States Department of Justice would want clarification of, which is whether or not the bread and butter every single day in America, like 26,000 times a year or whatever it is, someone is convicted under 922G1, which is the felon in possession. But here's the interesting thing. Did Merrick Garland and the Department of Justice for Joe Biden laser focus and try to get the Supreme Court to hear a 922G1 case involving felons in possession of firearms? The bread and butter routine thing that U.S. attorneys' offices see every day in America? They did not. What did they do? Instead, they laser focused on this Rahimi case. Now, Rahimi, like you mentioned, Stephen, refers to a different part of 922G, specifically 922G8, I believe it is, that says that if you are subject to a domestic violence restraining order, that's what it's labeled, you're not allowed to have a gun during the pendency of that restraining order. Now, keep in mind that in the context of a 922G1, which is the felon in possession, you've been at least convicted of a crime. In contrast, if you are subject to a 922G8 restraining order, you have not necessarily been subject to or convicted of a crime or anything. You're just subject to a restraining order that involves you and someone that's an intimate partner. It could be a wife, ex-girlfriend, a child, someone in the home, right? Somebody connected to you domestically. And that could be almost rubber stamped anywhere in America that simply says that you and your intimate partner, your ex-spouse, whatever it is, you each have to go to a separate corner. Neither of you can get close to each other. You're going to talk through lawyers. That's it. That's what we're going to do. These are entered every day all across America. One of the issues here is, of course, these are done without any kind of, in most instances, any kind of real procedural protections of anyone's liberty, including the right to keep and bear arms. So what's interesting right off the bat is, why did Merrick Garland and the Department of Justice want to push a 922G8 case, of which, by the way, there's approximately 200 or so convictions every year in America. So why are they trying to focus on a part of 922G that is rarely used in the federal system, and as opposed to laser focus on something that's used every day? And we know why, because DOJ thinks that the fact that Mr. Rahimi, allegedly is a bad guy involved in 5 shootings, that's going to somehow sway the Supreme Court to ignore the law, to ignore the Constitution, and to somehow bend over backwards to find a way to make Mr. Rahimi lose. And in the process of ensuring that Mr. Rahimi loses, by extension, screw up in some anti-gunner way, right? The Bruin methodology to screw up the Second Amendment jurisprudence that right now is very favorable to the Second Amendment and to to gun rights enthusiasts and proponents, and somehow screw all that methodology up so that in the future, all sorts of gun control laws that should be struck down will not be, because the Supreme Court will have bent over backwards to try to make Rahimi lose. That is the gamble that Merrick Garland wanted to take and has taken and forced upon the Supreme Court, rather than seeking cert on an emergency basis of some of those other cases, like the Range case in the Third Circuit, dealing with a felon in possession case where a guy 20 years ago was convicted of a food stamp violation under state law in Pennsylvania, has never committed any kind of crime since, no evidence of violence at any point in his life. And yet, coincidentally, strangely enough, Merrick Garland has not sought cert in that case, even though that deals with the traditional typical 922 G1, which is ubiquitous in contrast to the rare 922 G8.